Hi, I'm Dr. Anthony Edwards, and I'm the instructor for Higher Education Politics and Policy. And today we're going to be talking about authority and liability of colleges. So, when we think about the question of authority and where it comes from for colleges, it really depends on whether it's public or private. So, for public colleges, state administrative law as well as court decisions is what gives public colleges their authority. For private colleges, it tends to be state corporation law, trust law, as well as some court decisions because, again, because they are private institutions, they are structured differently. Okay. And, they're not state institutions. And then authority gets delegated from the board to the officers and employees of the college. Okay. There's different kinds of authority. So, terms you'll hear things like express authority, implied authority, apparent authority, and inherent authority. So, express means it's expressly stated, it's written. You find it in writing somewhere, either in the private corporation's charter or in the public institution, in the state administrative law. Implied authority is going to be not expressly stated, not written, but it's necessary or implied given the express authority. So in order to execute the express authority, there's some other authority that comes with it. Apparent authority sounds a lot like implied authority, but it's a little different. But here you have someone who has no authority for an institution, but they convince others that they do when they really don't have that authority. And that could result in harm or injury to the individual or organization, whoever's being harmed by it. And that harm is called estoppel. So you may see that throughout the chapter. Inherent authority is necessary for order and discipline. Okay. So in order to maintain order and discipline on the campus, there's a need for inherent authority. So, if you think about, there's this question of whether or not colleges have this inherent authority, particularly right now in terms of, things that happen on college campuses. Do they have the authority to do things in order to maintain discipline and order? And so there's, different colleges who handled that differently. Okay, trustee authority. So, again, you have board members, right? So in a public college, there's usually either a board, and it could be the board for that institution or a board for the university system. And usually that power or authority comes from the state statutes. And on the private colleges, they have their own boards, right? And typically the college charter or articles of incorporation is where the authority of those board members or trustees come from. Okay, so let's talk about institutional tort liability for colleges. Okay, so what's a tort, right? So you may have heard the term tort reform. A tort is basically a civil wrong, okay, that could be remedied in the court system. Usually there's some breach of duty, so it's going kind of beyond breach of contract. There's a breach of duty, and so in this case, someone who brings this forward would say the college didn't fulfill their duty, and it caused an injury to someone. Now, in terms of the liability, it can be separated out into common law liability and statutory liability. Again, from the name of the term, statutory liability comes from the statutes, right? And common law liability deals with things like negligence or defamation or contract law, which we'll talk about a little bit more detail in further slides. You may also see the term in the chapter respondeat superior, and that basically means that as the kind of superior role here, the institution is going to be liable for the acts of the students, the faculty, and the staff. There's some duty of control sometimes, so that you may say, or duty of control, like that basically because of their role, they should have done something. They should have taken care of something because they are the ones who are in control. Uh, the colleges may try to use what's called sovereign immunity, particularly in the case of state institutions, to say that they are as extensions of the state, that they are protected from litigation. Now, particularly, you may also see in some cases, whether or not the function is a governmental function. Are they doing something, whether it's a public or a private, particularly in the cases of privates. Private colleges, they may be taking on something that is a government function. And in some cases, they may try to ask for immunity, but in other cases, that doesn't really apply for private. But charitable immunity applies to pretty much any nonprofit organization, so that would include the public and the private institutions. So sometimes if the private colleges or public colleges don't meet the standard for sovereign immunity, they might meet the standard for charitable immunity. All right, in terms of negligence, it could be, essentially certain criteria has to be met in order for it to be negligence. The person has to be typically on campus lawfully. Typically, there's got to be some liability for the premises. So, like, they are responsible for where the institution is responsible for where the event took place. Could be related to instructional activities, co-curricular activities, or outreach activities. So even if it's off campus, it could be if it's related to these sort of activities, the institution may bear some responsibility. And whether or not there was some alleged educational malpractice that happened, or something happened that shouldn't have happened. So those four things, depending on one or more of those things, obviously the more standards that meets, the more likely there's a negligence claim. But those are typically four areas where essentially plaintiffs will try to say that the defendant has committed some form of negligence. Also here, some important concepts is foreseeability. So one of the keys to making a negligence claim stick is that the institution had to really been able to foresee that this situation could have happened. If they are able to prove that the institution couldn't have foreseen it, again, negligence is more likely to have occurred. If it's not something that's foreseeable, then it's less likely. Assumption of risk here, it's kind of, does the individual sort of take on some risk in working, if they're working in a lab and working with certain chemicals, are they taking on some risk that some injury could happen? If they are on campus and there are trails and hills on campus and there's signs up that says, hey, this, take care in these areas because you could hurt yourself, could result in injury. If they've warned you of that, are you assuming some risk by continuing on that path? Also, you may see the term fiduciary duty. Typically, you see that in financial institutions, and an organization that's a fiduciary is really assigned to do what's in the best interest of the client, and that sometimes can be used in higher education, but generally, institutions are supposed to do what's in the best interest of the institution. Obviously, that sort of usually will align with what's in the best interest of others, but sometimes that is not always a primary duty, so that sometimes doesn't always fit in higher ed. Okay, in terms of defamation, here what we're talking about is, you may see this in journalism and other professions, but there's a written or oral information that's put out, and it could cause injury to a person's reputation. Okay, that's what defamation is. So institutions sometimes ask for a conditional or qualified privilege, like in the sense here where we're talking about qualified, what we're saying is, there's this range that or latitude that's given in terms of appropriate criticism and comment. So if there are things that are written or said about an individual, uh, institution is asked for that privilege of being able to say those things because they are necessary, not because they're trying to defame the individual. So, example of that would be, if something is written about someone and if it's about a faculty member and their tenure and promotion, if someone makes in their mind what's an honest assessment of that individual or their performance, that may impact, whether or not that person gets tenure. Now, if the individuals who in the institution who are writing those evaluations feel that they wouldn't be protected, they wouldn't necessarily give it a realistic assessment of that faculty member. Could also happen with students and student evaluations. So there's some degree of protection, not necessarily unlimited protection, as you find out when you read one of the cases in the chapter. So, there's got to be documented evidence, can't be hearsay. So, so it's hard to make, making decisions based on hearsay can be really not a good thing for institutions. Also, actual malice is something that's important, particularly when we're dealing with when folks are public figures. You may like coaches, and in these days, in some cases with sports, sometimes students or student athletes are public figures. So if things are said about them, there has to be an intent for, you have to prove actual malice in order to say that their reputation has been defamed. Okay. In terms of contract liability and contract law, so the key with this is whether or not the actions were authorized. So when institutions go into contracts, whether it's the institution as a whole or people who work at the institution, one of the keys here is whether or not there's been authorization of action. So if there's no authorization, then it's hard to prove to say that there was actual liability. But in some cases, there's an argument that certain, the board, certain officers, people at a certain level in the organization are inherently there's some inherent authority that they have, or some implied authority that they have, and it is sometimes can hold the institution liable for the actions of those individuals. Okay, now let's talk a little bit about federal constitutional rights and whether the institution is liable. So you will see that term Section 1983. And these are typically dealing with actions that are, attributed or given to the state. So private institutions usually not kind of fall within that Section 1983 liability. And the liability would be imposed on a person, in quotation. So if you know anything about corporation law, there was a law that essentially said that corporations can, essentially be treated as people and have rights, that are associated with people. But again, depending on the type of organization that we're talking about with the state institution, it may or may not be structured as a person, so to speak. But they may have already met the criteria for immunity in terms of actions related to the state, depending on what it is. And there's no qualified immunity from liability for the state institutions or their officers or employees. So basically, again, there are certain scenarios where the state institutions would be responsible in a sense. There are, in terms of Section 1983, essentially what they're saying is that the state institutions are not exactly the same as the state of Texas or the state of Oklahoma. Now, where it gets a little more complicated is when we look at the 11th Amendment, and it does provide some immunity for states and state institutions. And so it may not necessarily meet the Section 1983 immunity, but it would some state organizations or state institutions would meet immunity based on the 11th Amendment. And in terms of, again, looking at this liability from the federal context, they're looking at things called Fitchick factors. Okay, questions that kind of go through in justifying this is: would the judgment payment come from state dollars? So if the state had to pay, would state dollars be used to pay the judgment? And what's the college's status under state law? How are they organized? They're 501c3, a C6, a C1. How are they organized? And how much autonomy does the college have? I mean, can they just make whatever decisions they want based on the way that they've been given in state statute? Do they have to report to a board, a coordinating board? Are there certain decisions that they can't make on their own? So all those things are in terms of determining the level of liability the institution has. All right, so that's basically an overview of the chapter for this week. You've got 2 assignments. You have a discussion over the chapter and talking about 3 concepts that stood out to you, and also commenting on at least 2 of your classmates' posts. And then we have the higher education politics and policy observation assignment, so you can observe a website or a person or video, or so there's a lot of different options here. But you can do an observation of some typically college that's related to your expert area and or college system, depending on what your group is, and looking at issues related to your topic in higher education policy and law. So again, this would be different from maybe observations that you've done in other classes, because here the focus or the lens is going to be policy and law. And you'll do that in your group discussion area in Canvas. So look forward to reading your posts and interacting with you. If you got any questions, you can email me in Canvas. If you like this video, please subscribe, like the video, subscribe to the channel, share the video with folks who think would find it helpful, and we'll see you in the next video. Thanks. Bye.